Hello guys, I'm Andrew from Seoul Law Group and we are an English-speaking law firm based in Seoul, South Korea. Today we're back and we'll be talking about deportation and departure orders in South Korea. Although we hope it never comes that far, the South Korean Immigration Office has a right to remove or deport any person who has violated the Immigration Act. This means that the Immigration Office can issue a departure order or deportation to people who have been convicted of a crime or to people who have in any other way violated the Immigration Act. In this video, we'll provide an overview of what a departure order and deportation are, when they're issued, and how you can appeal them. Appealing a departure order or deportation is very complicated, but definitely possible with the help of experienced lawyers. The difference between a departure order and a deportation. First things first, the departure order and deportation are not the same. Departure order is given when a foreigner voluntarily admits to their crime and agrees to leave the country peacefully. Usually, the subject signs several documents that state that they will leave South Korea voluntarily within a certain amount of time. A deportation is a more drastic and coercive measure. When issuing a deportation order, the Immigration Office will immediately take action so that the foreigner will leave the country. This can even mean putting the foreigner in a detention unit until they're put on a plane. If someone who has signed the departure order refuses to leave, they can also be deported. When is deportation or departure order issued? Article 46 of the Immigration Act of South Korea clearly states in which instances a foreigner is subject to a departure order or deportation. Clauses 1 through 5 of Article 46 stipulate that you can be subject to a departure order or deportation if you have falsely or incorrectly entered South Korea. For example, if the passport provided upon entry was a false passport, if the invitation letter provided was falsified, or if there are any other reasons your entry should have been prohibited, but somehow you're here in Korea. Clauses 6 and 7 apply to ships, their passengers, and crews. If you're on a ship and want to land on South Korean soil, you should meet several requirements and obtain permission by Immigration Office. If you enter South Korea through a ship without permission, you can be subject to deportation or departure order. Clause 8 states that you can be subject to a deportation or departure order if you do not comply with your visa's specific regulations regarding the duration of the sojourn and activities during this sojourn. Simply said, this means that you cannot overstay your visa and can only do those activities that your visa permits. For example, if you're on a D2 student visa, you're not allowed to work full-time. If you're on an E7 visa for engineering, you're not allowed to work in a different field. Clause 9 stipulates that you have to obtain permission from the Immigration Office before changing your workplace. Finally, clauses 10 through 14 stipulate some other instances in which someone could be deported, such as not filing for alien registration, making a false alien registration number and using it, or fraudulently using another person's alien registration certificate. Most importantly, you could be subject to deportation or departure order after having been sentenced for a crime. The departure order or deportation order is usually served after the person has been released from their sentence imprisonment. It is important to note that permanent residents of South Korea cannot be deported from the country unless they have committed a serious crime, such as murder, robbery, sexual crimes, illegal drugs, kidnapping or abduction of children, forming an organization or group aimed at committing violence, and etc. Even if your crime is minor and you can get sentenced to only a fine, being deported is unavoidable as long as your crime fits in these categories. Permanent residents can also be deported or ordered to leave if they have helped other foreigners illegally enter the country. Although Article 46 of the Immigration Act clearly states the instances in which foreigners can be deported, in reality it is often not so clear. For example, the Immigration Act does not state that foreigners can be deported after having been sentenced to pay a fine. But in reality, the Korean Immigration Office does sometimes issue departure orders when the fine is over 3 million Korean won. That is why it is important to always consult a lawyer when you're sentenced, arrested, or sued for any crime to help prevent potential deportation. Procedure of deportation and departure order in Korea. The Korean Immigration Office is allowed to review any foreigner's case and issue departure orders or deportation if they deem it necessary. Usually, the immigration office first has an interview with the foreigner to assess whether the order should be issued. If a departure order is issued, the immigration officer will ask the subject to sign legal documents in which the foreign subject acknowledges their wrongdoings and promises to leave Korea within a certain period of time. The foreigner can use that time to quit their job, move out of their house, and etc. If the immigration office decides to deport someone, an officer will deliver the deportation order directly to the foreigner and will immediately take action to ensure that the person will leave the country. The immigration office is allowed to detain people in foreign detention center if they believe they're a flight risk. The maximum duration of stay is 10 days, with an additional extension of 10 days possible, appealing a deportation and departure order in Korea. Although the immigration office is legally allowed to decide whether or not to deport someone, these decisions are still subject to legal review by the court. This means that anyone who has received a departure order or deportation is allowed to appeal to the court to have the case reviewed. Filing an appeal does not automatically mean that your departure order or deportation will no longer be valid. A court still might uphold the order if they think the immigration office made the right decision. Working together with qualified Korean immigration lawyers can help your chances of having your appeal recognized. There are three kinds of appeals: objection, administrative appeal, and administrative suit. Objection. An objection is simply a written appeal made to the Minister of Justice of Korea through the head of the immigration office within 7 days of receiving the departure or deportation order. The Minister of Justice would decide whether they will sustain the objection or not. Even if the objection is overruled, the Minister of Justice can grant a special permission to stay if the subject formerly had a Korean nationality or in other exceptional circumstances that they need to stay in Korea. Administrative appeal. An administrative appeal is pretty similar to a lawsuit, but there are a few differences. It is filed to Administrative Appeals Commissions and not the court. The Administrative Appeals Commission should make a decision within 60 days, which is much faster than the lawsuit. And if your appeal is dismissed, you can try it again by taking it to the actual court. This is nice if you want a simple and quick result compared to lawsuits. That is why many people try administrative appeals first and then file the lawsuit when it is dismissed. But you can file the lawsuit directly without administrative appeal. Administrative suit, which is also called revocation suit, is a lawsuit filed to the court against the immigration office, claiming to revoke the departure order or deportation. This suit must be filed within 90 days after the notice of the order or 180 days after the order was issued, whichever comes first. When the suit is filed against the departure order or deportation, the Korean court will mainly look at two things. First, whether the order of the immigration office complies with the law. Second, whether the immigration office has abused its discretion. Firstly, the court will review whether the departure order or deportation is valid within the Immigration Act. Secondly, it will also review whether the Korean Immigration Office has abused its discretionary power. This means that the court will determine whether the decision by the Immigration Office does more harm to the life of an individual than it does good to the Korean public. If that is the case, the deportation order could be revoked. To establish whether the Immigration Office has abused its discretionary power, the court will look at whether the plaintiff has their family in Korea, the seriousness of whatever reason made them to be deported, the harm done to the plaintiff if they are deported, and the good this individual has done to Korean society, etc. Korean courts do not simply look at the text of the Immigration Act, but consider the case as a whole to see whether the Korean Immigration Office has abused its discretionary power. In fact, there have been several cases in which the departure order or deportation was revoked based on this abuse of discretionary power. Administrative suits are not easy because it is important to make a good case that shows the overall character of the person subject to deportation. That is why it is highly recommended to immediately employ a legal service that can help you build a strong appeal if you have been issued a departure order or deportation. Well, I hope this video was useful for you. If you have any questions or concerns about deportation in Korea, please let us know in the comment section below, and you can find more information on seullawgroup.com. Don't forget to like, subscribe to our channel, and turn on the notification bell for more Korean law videos. And we hope to see you next time. Bye-bye.